Hi everybody, good evening and welcome to Thorough Newspaper Analysis. This is the video for 3rd of June 2024. Now let's proceed and have a look at the pointers of discussion for the day. So first of all, we have the editorial segment, and here we talk about an Indian Express article which carries the heading, Delhi government moves Supreme Court, legal history of Delhi's water dispute with other states. Secondly, we talk about the news updates. And lastly, we have a look at the legal news. So without further ado, let's start and let's first have a look at the title of this article that we've already discussed though. Delhi government, it moves Supreme Court. So what is the legal history of Delhi's water dispute with other states? Here essentially, please understand, we'll talk about the water shortage that Delhi currently is facing, the crisis, and which is aggravated, worsened by the current heat wave, the surge in temperatures. And we'll understand what is the issue that the government of Delhi is facing due to the non-cooperation by the Haryana government. So first, let's have a look at the context and understand what has happened. So the Delhi government, it has approached the Supreme Court seeking urgent directions to Haryana and Himachal Pradesh to seek more water into NCT region, which is the National Capital Territory. This move, it has come due to unprecedented surge in temperatures, thereby leading a rising demand for water and the non-availability of the sufficient water which is needed to cater to this supply, to this demand. Now, this is not the first time that Delhi government has approached the Supreme Court over water crisis. We'll understand something that happened way back in 1995 and the 1996 ruling of the Supreme Court in this particular case. We'll also understand a MOU, a Memorandum of Understanding that is signed between Haryana, Delhi, UP, Rajasthan and Himachal Pradesh over the sharing of water of Yamuna River. So let's start and understand why the government of Delhi, it has approached the Supreme Court. See, despite taking several measures, the Delhi government, it has not been able to tackle the water shortage issue. All of this, it is as per the petition of the Delhi government before the Supreme Court. So this has precipitated an emergency in the form of a full-fledged water and sanitation crisis. And as a result, it has necessitated an emergent solution. This was according to the government's petition. The AAP government also said that Himachal Pradesh government has although agreed to share its surplus water with Delhi, but the problem is that this surplus water from Himachal, it has to be transported through a barrage, which is the Wazirabad barrage, and this is not happening because of Haryana government's non-cooperation. So this is what the petition stated, that but the water will have to be transported through the Wazirabad barrage with the Haryana government's cooperation, but this isn't being provided currently. Now let's understand what is a barrage. See, unlike a dam where water is, it is put at a stoppage for some time, and then there's the process of electricity creation, and then water is, allowed to flow. But in a barrage, essentially what happens is the water flow is cut, and then the water is diverted to some other place. So let's say there is a river, and the drainage basin of this river is covering area X. But there is a state B, there is an area B, which does not have any natural water source. So how do we cater to its water demand? So this is what we do. We, sort of divert the water from this river body, and then we divert the water to this parched area, so to say, which does not have its own water body supply. So this is what a barrage does. So adding that the water levels in Sonia Vihar and Bhagirathi barrages, which are the other primary sources for Delhi NCR, they are operating at its full capacity. So these barrages, they cannot need any other help because they are already operating it at its full capacity. So therefore, the government contended that an increase can only be considered at the Wazirabad barrage, and this can happen with the surplus water that Himachal Pradesh is willing to provide, but the cooperation from the Haryana government is needed. However, despite requests to the Haryana government to release surplus water, there has been no positive response. This is Delhi's plea, stating that additional water supply is necessary due to NCR's large workforce, which also include a large chunk of migrant population. The government added that it was only seeking relief as a temporary, a stopgap arrangement until the monsoon season's arrival. And once the monsoon hit India and Delhi, then the water shortage, it should be addressed to a significant level. Now let's understand what are some of the other instances when the Supreme Court was approached. So for that, we have an order of the Supreme Court, which was clarified by the court to be an interim order somewhere here. We'll understand. So this order goes back to 31st of March 1995, when the Supreme Court passed an interim order acting on a plea. This plea was filed by S.D. Sinha, and it sought direction to Haryana to maintain a regular flow of water in Yamuna River and drinking water shortage in Delhi, amid the drinking water shortage in Delhi. So in response to this plea, the Supreme Court back in 1995 ruled and said, and I would like to quote it out, Delhi, which is in dire need of water, it is to be given its allocation of water with immediate effect. We therefore direct all the parties to the Memorandum of Understanding. Now, which is this MOU and what are these parties? Which states are party to this MOU? So this MOU is the one which was entered a year ago when talked in reference to 1995. So this was entered in 1994, and the concerned states are these 5 states. So the Supreme Court said that we direct all the 5 states, the 4 other states, excluding Delhi, to the Memorandum of Understanding to assure that sufficient water, which is about 2.5 times of the seasonal allocation, it is released. So this is, with respect to that order, for our purpose, this should be sufficient. Now, since we've been talking about the MOU, let's understand what is that. But before we do that, let's understand the concept of what is a basin. Please understand, basin is a depression, a circular sink-like depression in the land. Now, this can be created due to a couple of geographical or man-made phenomena. One such is the natural phenomena of drainage of river. So suppose this is an area, it is drained by a river. This area, which is drained by a river and all of its tributaries. Now, in our case, suppose this is the area from which Yamuna River goes. It is drained by Yamuna River. Yamuna has its tributaries. So all of these tributaries are also flowing through this particular area. It is the drainage of the river Yamuna and its tributaries. So because the river has been going on from this area for so many years, such long span of time, so there's erosion of the land, the rocks which come in their path, and there is a deep depression which is created in the land. So this is how the basin system of a river, it is formed. Now, Yamuna River, it has its upper basin, its lower basin. The areas, 5 areas which fall in the upper basin of River Yamuna, they have signed this MOU. Now let's understand this. So signed by the chief ministers of 5 basin states on 12th of May 1994, including Haryana, Delhi, UP, Rajasthan, and Himachal Pradesh. This MOU, it dealt with allocation of Yamuna water amongst these co-basin states, and they fall in the upper Yamuna basin. And this was the allocation is by board under the Department of Water Resources, River Development and Ganga Rejuvenation, Union Ministry of Jal Shakti. So this is the concerned department, and this is the board which is going to be responsible for this. It stated that when the availability of water, it is less than the assessed quantity. Now, suppose the assessed quantity is X amount, but the water is less than that. So then how do we, go about catering to the needs of these states? Now, it was agreed upon in this MOU that first preference must be given to Delhi. So the drinking water allocation of Delhi has to be first met, while the balance, it will be distributed among the remaining 4 states in proportion to their allocations. Now, the bench had also issued directions to Haryana and UP through their chief secretaries to release the water for consumption of Delhi. So this is with respect to that. And the Supreme Court also, further categorically stated that this is an interim measure till the time the members of the board and the review committee, they were appointed, until the time this board becomes functional. This board, which was referred to in this MOU of 1994, and this order is just a year later of 1995. In the aftermath of 1995, however, because there were non-compliance of this order, so there were 2 contempt petitions which were filed. So let's talk about those. So 2 contempt petitions were filed before the Supreme Court, and these petitions alleged that there was willful violation of the order of 1995. These culminated in the 1996 ruling in the case of Delhi Water Supply and Sewage Disposal Undertaking versus State of Haryana. So, disposing of the contempt pleas, a bench of the Supreme Court in February of 1996 ruled, and I would like to quote it out: Delhi shall continue to get as much water for domestic use from Haryana through river Yamuna, which can be consumed and filled in the 2 water reservoirs and treatment plants at Wazirabad and Hyderpur. Both Wazirabad and Hyderpur reservoirs, they shall remain full to their capacity from the water which is supplied by Haryana through river Ganga. Also, the court directed Haryana not to obstruct the supply of water to Delhi as directed by the Honorable Supreme Court, while adding that its order was independent of the MOU which was signed between the states. So in very stern voice, very clear and categoric terms, the Supreme Court stated that this time around, the concerned government, here let's say the government of Haryana, will not violate the order and the direction of the Supreme Court. And if it does so, then the concerned officials will be, they will be dealt accordingly. So the Supreme Court said, I would like to quote it out: we therefore close the proceedings by requiring Haryana to make available the aforesaid quantity of water to Delhi throughout the year. Let it be made clear that any violation of this direction, it would be viewed very seriously, and the guilty persons would be dealt with appropriately. So it said that if there is any violation, contempt of the order of the court, there is violation of the court's directions, then that would be viewed very seriously and absolutely sternly, and the guilty persons would be dealt with accordingly and appropriately. However, in 2021, when the water level in Wazirabad pond, which supplied water to the treatment plants in the city, it dipped to a certain extent, the Delhi Jal Board, it filed a petition before the Supreme Court with the allegation that there is willful disobedience of the 1996 ruling by the Haryana government. So now let us try to understand whether this order, it was interim in nature, or whether this order was to persist forever. So let's see that. Now, in its plea, the Delhi Jal Board said that the Haryana government was stopping the water supply to the national capital and was not releasing 120 million gallons of water per day. However, the Haryana government said that the situation of Delhi, it was caused because of its internal mismanagement. When the matter came before the Supreme Court in July of 2021, a bench of 3 judges dismissed the batch of contempt pleas filed by the Jal Board seeking action against Haryana government. So why was why were these pleas they were dismissed? What was the reason behind it? So saying that the 1996 order, it was passed as an interim measure till the time the members of the board and the review committee were appointed and it became functional. The Supreme Court said that the Delhi government couldn't resort to the same now, owing to the large-scale infrastructural development that have taken place since February of 1996. So the court categorically said that the earlier order, it was as an interim measure till the time the board was not operative. So it was just, for the time there is a gap in the system, as in there is no board constituted. So since once the board is constituted, its review committee is appointed, then this order will vacate. So it became functional. Once the board became functional, till that time only the order was to persist. Further, the court reflected upon the fact that there is large-scale infrastructural development also that has happened since 1996. So, for instance, it noted that since 1996 order, 3 additional water treatment plants have also come up, namely Bhavana, Dwarka, and Okhla. So, therefore, dismissing the Delhi government's case, the Supreme Court said, and I would like to quote it out: the petitioner has failed to make out any case for contempt against the respondents. The petitioner is cautioned to be careful in filing petitions repeatedly for a relief which has been rejected by this court on earlier occasions. So with this, now let's proceed to the national news, and this is the first update here. Considering major issues which are faced by migrant workers in immigration process, three government bodies, they've come together to create a synergy, to create a cooperated, very well placed and put together system to provide e-migrate services through common service centers across the country. And this is essentially to help those who are, are trying to seek employment abroad, and at times they are made fools because of the fact that there are very unscrupulous sort of agencies and people who are trying to reap the advantages of really gullible and innocent people out there who are just trying to have an aspiration for making their work aspirations come true abroad. So here the Ministry of External Affairs, Ministry of Electronics and Information Technology, and these common service centers, e-governance services India Limited, all of these three entities, they've signed an MOU to create a synergy between these centers and the Ministry of External Affairs to provide the e-migrate services through these common service centers. This was signed to broaden and the safe and legal migration pathways, especially to guard against unscrupulous individuals who are taking advantage of Indian nationals who are seeking work abroad. This is a very interesting update. So far we've been covering news with respect to our science and space technology advancement, and we often see the name or the involvement of ISRO behind, let's say, any rocket launch or any other space related technological advancement. But here a private space company has successfully launched its indigenously built rocket. So this is a very huge and very welcoming sort of an update, which is garnered support and appreciation from prime ministers and others in ISRO as well. So a private space company, which is called Cosmos, it carried out the first successful launch of its indigenously built rocket last week, opening up a new chapter in India's space sector. And please understand, this is not the first time that a private entity has, successfully made such sort of a test launch. Earlier in November of 2022 also, Skyroot Aerospace, which is a young space startup, it just like Agnikul that we saw, it successfully launched a rocket, which it has named Vikram after Vikram Sarabhai, who is the legendary space leader credited with building ISRO in the initial years. Now let's talk about the inaugural, flight of Agnikul's rocket. So the inaugural flight of Agnikul's creatively named Agnibaan rocket. It builds on the success of Skyroot and it signals to the range of options that India has in its space market. So the name of this rocket is Agnibaan. The company concerned is Cosmos, and this is a private entity which has successfully launched its indigenously homemade or built rocket last week. This is a very important update. India assumed chair of Colombo Process for 2024 to 2026. India, it has become chair of the regional grouping called Colombo Process for the first time since its inception in 2003. So let's talk about what is this group. So this is a regional consultative process of migrant workers who origin from countries, let's say, in South or Southeast Asia. It serves as a forum for exchange of best practices on overseas employment. RBI imposes rupees 36.38 lakh penalty on HSBC for violating Fema regulation. Let's talk about it. So the Reserve Bank of India has imposed this penalty on foreign lender, which is HBC. And this is HSBC. This is for Fema violations. What is Fema violation? It is Foreign Exchange Management Act violation. The central bank said reporting requirements under the liberalized remittance scheme of Fema 1999, they were not followed by this entity. RBI had issued a show cause notice to SSBC earlier, in response to which the bank submitted a written reply, and also made oral submissions, and following that, the ban has come about. The penalty imposition has come about. REC, it wins Sustainable Champion Editor's Choice Award. REC Limited, what is it? It is a Maharashtra Central Public Service undertaking. So this is under the Ministry of Power, and it is a leading non-financial banking institution. It has been honored with the Sustainability Champion Editor's Choice Award, and this happened at the Outlook Planet Sustainability Summit and Award for the year 2024. This award recognizes REC's commitment to sustainability initiatives and its efforts in driving process towards a greener future. Health insurance, this is an update with respect to that. The Insurance Regulator and Development Authority of India, IRDAI, it has made some major changes in the regulatory norms of health insurance policies. It sets 3-hour time limit for insurers to clear cashless claims. The regulator has issued a comprehensive master circular on health insurance products, repealing 55 circulars. All the entitlements in a health insurance policy available to a policy holder, they have been brought in one place in this master circular, which has replaced the earlier 55 circulars. If I were to talk about the agency concerned here, the regulatory body, which is the Insurance Regulatory and Development Authority of India, it is an autonomous and statutory body under the jurisdiction of Ministry of Finance, Government of India. It is tasked with regulating and licensing the insurance and reinsurance industries in India. It was founded way back in 1999. Now we talk about the important days for the day, and the day concerned first is World Milk Day 2024, and second is Global Day of Parents. This is such an important, day to celebrate. World Milk Day, it is celebrated every year on 1st of June. So is the case with Global Day of Parents. Let's talk about Milk Day specifically firstly. So this day, it is celebrated to bring the importance of milk as a global food to forefront and to promote dairy farming and dairy industry. Milk Day, it established by the Food and Agriculture Organization, the FAO of the United Nations. It has been observed across the world since its inception in the year 2001. According to FAO, it is the Food and Agriculture Organization of the United Nations. This day was picked because several countries already had a National Milk Day on or around this particular day. As far as the theme for this day is concerned, it is dairy is an accessible, affordable, and nutrient-dense food. It is an essential part of balanced diets across the world. Global Day for Parents, it is observed on 1st of June. Let's talk about the history of it. The history of the Global Day of Parents, it dates back to 2012. So this is a very recent commemoration when United Nations General Assembly declared 1st of June as the International Day of Families. The day was established to highlight parents' significant role in their children's development and promote their healthy growth and development. 2024, it marked the 12th observance of this particular day. Now, this has brought us to the international segment, and the first update is from Pakistan. Former Prime Minister of Pakistan, Nawaz Sharif, he admits or has admitted that Pakistan violated peace agreement with India in 1999. Which is this peace agreement? It is the Lahore Declaration. Sharif's disclosure, it unfolded during a meeting of the PMLN. This is the political party which belongs to Nawaz Sharif. So during its General Council meeting, he made this disclosure where he assumed the presidency of the ruling party 6 years after his disqualification by the country's Supreme Court. The agreement, it is the Lahore Declaration, which he and the then Indian Prime Minister Shri Atal Bihari Vajpayee, they signed on February 21st, 1999. You may make a note of it. This is the Lahore Declaration. It goes back to 1999, signed between him and Atal Bihari Vajpayee with the goal of fostering peace and stability between India and Pakistan. However, shortly after the signing, Pakistani troops infiltrated Kargil district in Jammu and Kashmir, leading to the infamous Kargil War. During this General Council meeting, he asserted that he conducted the nuclear tests despite facing pressure from the United States and subtly criticized Prime Minister Imran Khan. This is also an interesting update. Poland unveils East Shield, massive defense barrier to fortify borders with Russia and Belarus. So essentially what Poland has done is it has sort of sealed its border with Russia and Belarus. And it has not done it by making a wall, so to say, but by building and creating structures like minefields, bunkers, anti-tank trenches. So Poland, it has revealed plans. So it is just planning at the stage of planning. This is the update. So it has revealed plans to build a line of minefields or bunkers and anti-tank trenches. And this is planned alongside the border with Russia and Belarus. The government will request for financing for the border wall from European Union. The project is scheduled to begin this year and finish by 2028. It is called East Shield. It has been promoted as a deterrent to prevent an assault from Russia. Plans are purportedly being developed in cooperation with Lithuania, and then we have Latvia and Estonia. Poland, it borders Belarus, Russia's close ally, by 170 miles, and as far as Russia is concerned, it goes 130 miles. Ex-Olympic pole vault champion Braz is banned for doping. This is an important update, and as a result, he is to miss the Paris Olympics. So, Olympic pole vault gold medalist Thiago Braz, he was banned for 16 months for doping and will miss the Paris Olympics 2024. He won the Olympic title at his home, Rio de Janeiro, and this happened in 2016, and he took bronze in Tokyo 3 years ago. The 30-year-old's ban, it expires in November, and he has filed an appeal to the Court of Arbitration for Sports. As far as the World Agency with respect to doping is concerned, it is the World Anti-Doping Agency, also popularly called the WADA. It is a foundation initiated by the International Olympic Committee based in Canada to promote, coordinate, and monitor the fight against drugs and doping in sports. This was founded way back in November of 1999. Kenyan delegation, it shares a draft MOU on wildlife conservation with Tiger Authority. A 6-member Kenyan government delegation that visited India last week to appraise India's work on Project Cheetah, it presented a draft MOU to the National Tiger Conservation Authority, thereby outlining collaboration in the field of wildlife conservation, capacity building, and knowledge sharing. India has been exploring the option of outsourcing cheetah from Kenya. So why is Kenya, being interested in drafting the MOU term? The reason is this, because India has been exploring the option of outsourcing cheetahs from Kenya for phase 2 of Project Cheetah. What is Project Cheetah? It is India's ambitious attempt to introduce African cheetahs in the wild in our country. And it has been completed a year after its launch in September 2022, the first phase. Now, for second phase, India is considering exploring the option of bringing cheetahs from Kenya. And why Kenya and African nations? Because it is believed that they would adapt better to India's tropical climate, since a part of Kenya is located in the northern hemisphere. Now, with this, we come to the legal news update segment, and this is the first update which comes from the Allahabad High Court. So, the Allahabad High Court bench, it has held that an arbitral award, it should only be set aside if it is clearly vitiated by patent illegality. It is clearly null and void vitiated because of a patent illegality evident on the face of the record. The bench further added that an award, it cannot be annulled merely due to an incorrect application of the law or misinterpretation of the evidence. It can be vitiated only because of a patent illegality which is evident on the face of the record. So this was further reiterated by the court. So it was reiterated that an arbitral award should not be set aside unless it is vitiated because of patent illegality, which is, prevalent, seen on the face of it only. It held that an award should not be set aside because of erroneous application of law and appreciation of evidence. This happened in the case of National Highways Authority of India versus Ram Pyari and another. Next up is an update from MP High Court. The question that the High Court has answered in this particular case was, does agreement of separation between married couple amount to divorce? Let's see the fact of this case first. See, a husband and wife, they got married on a certain date in, April of 2022. And later, the wife alleged that she was subjected to taunts for dowry from her husband and in-laws. And as a result, she is compelled to live with her parents due to the cruelty, the harassment by the husband and the relatives of the husband. And therefore, an FIR was lodged against the husband and his relatives under all of these sections. First is 498A, which is cruelty, 406 and 34, read with 34 of the IPC, and sections 3 and 4 of the Dowry Prohibition Act of 1986. I believe it's 1986 only. So these are the facts. So basically what has happened, the marriage between these two, it was solemnized on 21st of April 2022. And thereafter, the wife is alleging that she was subjected to cruelty and harassment by the husband and his relatives because of unfulfilled dowry demands or because of dowry, more dowry that they're claiming. So as a result, she is living with her parents and therefore she has filed lodged the FIR. Now let's understand the contention of the husband. Why? Because the wife has filed the FIR, correct? So the husband now wants to quash the FIR. So therefore, the husband and his relatives, they are before the High Court under section 482, invoking the High Court's inherent power, saying that kindly quash this FIR. So the applicant submitted that divorce had taken place between the husband and the wife by executing a mutual agreement on 22nd of July of 2022. So because there was a mutual divorce between the husband and the wife, and the FIR was lodged on 20th of December 2023, which was much later than this mutual agreement of divorce. So therefore, they challenged the FIR based on the fact that there was no relationship between the husband and wife at the time of filing of the FIR. So husband is essentially saying that we already executed a mutual agreement whereby we divorced each other, and this happened before the FIR was lodged. So let's see what the High Court said about the validity in law of this mutual agreement. So the single judge bench of the High Court recently observed that a separate divorce agreement signed by a husband and a wife, it has no legal validity and does not amount to divorcing. The court said the agreement of separation has no sanctity in the eye of law. Therefore, it cannot be said that any divorce has taken place between the parties. Further, the court added that even otherwise, if any divorce has taken place, still the FIR under 498A IPC, which is cruelty, it can be lodged in respect of cruelty which was meted out to the complainant prior to the divorce, but that situation has not arisen in the present case. Why? Because no divorce in the first instance has taken place, because this mutual agreement, it has no legal sanctity and no value in the eye of law. So that's all we have for our TNA. Thank you so much for watching. Have a wonderful day ahead.